just $1,000 begins with its fair market value. That is measured from the time of the take. The error here is clear. The Pung home was worth $194,400. The tax debt was roughly $2,200. Just compensation meant returning remaining equity. The lower courts erred when holding that the later auction price of just $76,000 less the debt was categorically the only just compensation owed. But this court said it directly in Jacobs. An owner is owed just compensation, not inadequate compensation. Following Tyler, there are no windfalls to the government. This case now asks the court to confirm the other half, that the Constitution likewise forbids confiscatory losses when being imposed upon a former owner. Federal courts should consider all relevant evidence of market value and determine whether just compensation has in fact been paid. In addition to the Fifth Amendment, the Eighth Amendment's excessive fines clause provides a backstop as well. Taking a six-figure home to punish over a small four-figure tax constitutes a fine and was sufficiently alleged to be grossly disproportionate to get past the initial pleading stage. The judgment below should be reversed, and I welcome the court's questions.
What do you do with the fact that the English and American legal traditions seem to permit these sorts of foreclosures?
So the fact that our history allows for these types of foreclosures is only one half of the equation. The other half of the equation historically is that protections have been built in. For example, one of many is, for example, is personality has to be taken before the real property, for example. This process that Isabella County undertook lacked that second half of that historical tradition. Yes, surplus is the ultimate outcome if, in fact, the auction resulted in a fair market value. But when it doesn't result in a fair market value, historically courts have been allowed to challenge inequity, to set aside the foreclosure itself, or to otherwise award damages or compensation.